Pursuant to notice, I call up H.R. 5213, the Keep Violent Criminals Off Our Streets Act. For purposes of markup, I move the committee report it favorably to the House. The clerk will report the bill.
H.R. 5213.
Without objection, the bill will be considered as read and open for amendment at any point. And we'll do opening statements. Chair is recognized. H.R. 5213 prohibits the Attorney General from awarding Byrne JAG grants to state and local governments that have cashless bail policies for violent criminal offenses and offenses that promote public disorder. States and local jurisdictions use Byrne JAG grant dollars to fund many pretrial services that are used to assess and evaluate these offenders when they're released. Federal taxpayer dollars should not be awarded to states that have pro-criminal, anti-victim policies. Rates of violent crime have increased dramatically in Democrat-run cities over the past 5 years. Soft-on-crime prosecutors and legislators have implemented various bail policies that have resulted in more violent offenders being released back into their communities after their arrest. These laws and policies ignore public safety and create a revolving door for criminals. For example, in 2021, Illinois became the first state to eliminate the use of cash bail. Other states, such as California and New York, have modified their bail practice to significantly decrease the use of cash bail. These states continue to receive millions of taxpayer dollars in the form of Byrne JAG grant funding, some of which is used for pretrial services. For example, in fiscal year 2024, Congress appropriated $924 million to state and local jurisdictions in this Byrne JAG grant dollar program. Congress cannot continue to reward states and local jurisdictions that place their residents in harm's way for ideological purposes. I urge my colleagues to support the bill, and I yield back and now recognize the gentleman from Maryland, the ranking member.
Thanks, Mr. Chairman. I strongly oppose the bill. H.R. 5213, which I understand will be renamed the No Federal Funds for Cashless Bail Act, should really be titled the Defund the Police in Dozens of American Jurisdictions Act. That's because it would prohibit states or localities that have reformed their cash bail systems from getting any funds from the Byrne JAG program, the cornerstone of our federal public safety grant program, which supplies millions of dollars to police departments, prosecutors, and victim advocates across America to keep our communities safe. So instead of targeting criminals, this bill actually targets law enforcement, gutting federal funds that officers and district attorneys need to combat, prosecute, and punish crime. And it targets crime victims who rely on the support that Byrne JAG funds provide. Although this punitive, anti-local bill is hopelessly vague, it's apparently intended to punish jurisdictions that have enacted cashless bail for a set of covered offenses. And I want to be clear, Mr. Chairman, if someone awaiting trial is a danger to the community or they're a flight risk, it shouldn't matter how much money that person has, they should be detained, period. Everyone should agree on that. But there are some states and localities that have made the determination that if someone does not pose a risk, they should not lose their liberty simply because of their poverty. Half of Americans are living from paycheck to paycheck. Lots of Americans simply can't afford to put up the cash bail, even if they pose no risk to anyone else and no flight risk. And they shouldn't be forced to stay in jail simply because of the power and the financial contributions of the bail bondsman. It's up to a judge to determine whether a person can safely be released before trial and whether they can be expected to appear in court. But many jurisdictions have decided that if a person's not a danger to the community, their freedom should not depend on whether or not they can afford to post bail. Under Charles Dickens' cash bail system, wealthy defendants can effectively buy their way out of jail, while lower income people who pose no greater risk will languish behind bars indefinitely simply because they don't have the money for it. That really is out of A Tale of Two Cities. They say life is unfair, but that shouldn't be the law. That's why some states and localities have decided that reforming, in some cases eliminating cash bail, would help reduce inequity in the criminal justice system while ensuring public safety is protected. But this bill assumes Congress knows better than these communities and imposes harsh penalties on their citizens that would actually make them less safe by cutting law enforcement funding in a reprisal against them for policy reasons. Unfortunately, our colleagues want to play politics with public safety, but they're hurting the very people they say they want to protect. I urge my colleagues to join me in voting no on this gross federal overreach, and I yield back, Mr. Chairman.
Gentleman yields back without objection. All of the opening statements will be included in the record. The chair now introduces an amendment in the nature of the substitute. The clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of substitute will be considered as read and shall be considered base text for the purpose of amendment. This amendment changes the short title of the bill to the No Federal Funds for Cashless Bail Act. As the ranking member indicated, this change is not intended in any way to alter the important purpose of the legislation. I urge support of the amendment and yield back. Who seeks recognition? The gentleman from New York is recognized.
Mr. Speaker, I'm sorry, Mr. Chairman.
Been called worse. Yeah.
God forbid. Mr. Chairman, I rise in opposition to this bill for essentially the same reasons that the ranking member did. It is an anti-law enforcement bill because it cuts the Byrne JAG grants. And it does so in the name of opposing cash bail. But the fact is, cashless bail. But the fact is, cashless bail or almost cashless bail policies, like in New York, have worked. No one should go to jail pre-trial because he can't put up cash. No one. A judge, in every case, should decide on the flight risk or risk of bad conduct by a defendant based on all kinds of factors, except one, that is, whether the defendant can put up cash. That factor is irrelevant. The judge should decide to hold the person in confinement until trial or to let him go, based on all the myriad of factors that you would judge. States have gone in this direction. And states that have gone in this direction, like New York, which has almost the cashless bail policy, I wish we'd go further, have the lowest crime rates in decades. We have not seen lots of defendants released on cash, released before trial, commit crimes. As I said, the factors that lead to the risk of committing a crime before trial are weighable, are knowable and weighable by a judge. The one thing that shouldn't matter is whether you have money to buy your freedom. For this reason, I oppose this legislation and urge its defeat, and I yield back.
Gentleman yields back. I think we're waiting for Mr. Van Drew. Does Mr. Van Drew have an amendment? Does he? Who seeks recognition? Gentleman from Colorado is recognized.
Thank you, Mr. Chairman, and thank you to our ranking member. I want to follow up on a point that was made and articulated by my colleague from Florida during the prior debate, and I wonder if the chairman might engage with me in a bit of colloquy here, because as I understand it, we can find no record of an Attorney General of the United States not testifying within the year in which they were confirmed for the better part of the last quarter century. Are you aware, Mr. Chairman, you've been in Congress a long time, of an Attorney General, what was that?
I'll wait till you finish your question.
Are you aware of an Attorney General?
I don't know if
Mr. Barr, Mr. Garland?
I will tell you,
Mr.
the Attorney General is scheduled to be here. She was scheduled to be here during the whatever 43-day shutdown that you guys orchestrated, but she's now scheduled to be back in next month.
Well, it's interesting. I'll just say, the shutdown did not stop any of the other Republican chairmen within the House of Representatives from securing an appearance from the individuals who serve in the president's cabinet. Did not stop any of Attorney General Bondi's
Like
peers.
I said, she was scheduled and she's
Mr.
coming in
Chairman,
February.
I'm going to reclaim my time on this front because I find it to be the height of hypocrisy, having served on this committee for several years, having heard my colleagues bemoan the fact that Attorney General Garland took until September, October of 2021 to testify in front of this committee, that they cannot be bothered, that the Attorney General of the United States won't testify in front of this committee, apparently until next month, although this isn't the first time we've heard from the chairman that the Attorney General is slated to testify. And then, of course, as fate would have it, the hearing is is canceled or no longer scheduled and all the rest. So I look forward to that hearing. I hope the chairman is a man of his word and that he can commit to us that that hearing will take place and that the Attorney General of the United States will testify in front of the committee that has jurisdiction and oversight over her department. If the chairman's willing to make that commitment, is that?
Like I said, she's scheduled to be here next month. We've had the director of the FBI. I don't believe any committee had any hearings during this 43-day shutdown that you guys put together.
Most of them scheduled their oversight hearings before that. So in any event, I look forward to that hearing. I yield back the balance of my time. Or I yield to the ranking member, sorry.
Thank you kindly. I wanted to say a word in response to the gentleman from California, Mr. Issa, who said, as to the terrible killing of the 37-year-old mom, Renee Good, in Minnesota, that he would reserve judgment, something obviously the president did not do, something that the director of Homeland Security did not do. He would want to see. And I appreciate the fact that he did not reject my suggestion to think about Ashley Babbitt, because there's some people who seem to think that the legitimacy of a police killing of a citizen should be based on the politics of the person who's killed, which is just outrageous and dangerous, okay? And so when Ashley Babbitt was killed, I said from the very beginning of that, there's got to be an investigation to see whether this was a lawful use of force or not. And there was an internal investigation in the Capitol Police Department that found it was a lawful use of force to defend both the officer and the members of Congress from the entering mob. And then the Department of Justice came to the exact same conclusion. Nonetheless, our colleagues and the Department of Justice took the position that there should be a $5 million payout to Ashley Babbitt's family, despite the fact that there were investigations exonerating the police officer in that case. Now what we've got is the president and the Homeland Security Department asserting peremptorily, summarily, that this was self-defense in this case, and in a way totally contrary to the evidence of our own eyes. If we're going to come to a snap judgment, then I'm with the people who are saying that was murder. If we're going to come to a snap judgment, if we're going to act like lawyers on the Judiciary Committee, then let's say, well, we will allow the investigation to continue and we'll allow there to be some just conclusions made. But nonetheless, from the standpoint of public safety, we've got to get in control of ICE. Thank you, and I yield back.
Gentleman yields back. Gentleman from California is recognized.
Thank you, Mr. Chair. If the politicians in my state at the state level had their way, then cash bail would have been abolished in California. There was a bill to do just that. It passed our legislature and was signed into law by our governor. But then the people of California weighed in. That measure was subject to a voter referendum that appeared on the ballot, and the people of California voted overwhelmingly, 56% of the vote, to overturn the law that had been passed by our legislature and signed by the governor to abolish cash bail. Because the people of our state are tired of this decriminalization agenda that has continued to lower the consequences for crimes and to take tools out of the hands of law enforcement and to allow for early release of dangerous offenders back into our communities. I'll add, incidentally, that history repeated itself last year when the voters of our state overwhelmingly overturned a measure that lowered the consequences for retail theft and drug crimes, despite the governor and the leaders in the legislature opposing this initiative last year. The people of California passed Proposition 36 to restore reasonable penalties with an overwhelming 68% of the vote. So to the extent that it's relevant to how anyone votes on this measure, I just thought it was worth noting that even in a left-leaning state like California, an overwhelming majority of the people believes that these policies of abolishing cash bail and the other decriminalization policies that have gone with it are completely reckless. And I think that this is a common sense measure to assure and do whatever we can to assure that these sort of reckless policies are not adopted throughout the country. I yield back.
Gentleman yields back. Gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman. I understand that our Republican colleagues would much rather talk about cash bail today than about the fact that an ICE agent shot and killed an American citizen in Minneapolis yesterday, because that's what happened. A masked ICE agent shot and killed Renee Nicole Good, a 37-year-old citizen, a young mother in Minneapolis. This is a tragedy, apparently a preventable tragedy, and I'm heartbroken for her family, her loved ones, and her community. But I'm also angry and heartbroken for our country. How is it possible that we are doing anything else in this committee today? I completely endorse my Democratic colleagues' calls for an investigation, for hearings, because where is the accountability? That is Congress's job. Where's the response from this committee's leadership? The White House immediately branded Renee Good, this young mother, this American citizen, as a domestic terrorist and claimed she had violently attacked ICE agents. But soon thereafter, video footage and eyewitness testimony emerged that directly contradicted the White House spin. There's eyewitness testimony that the agents gave Renee Good conflicting directives and video evidence that she tried to wave the ICE agents around her car and steer around them. That's why it's all the more egregious and demanding of both condemnation and congressional investigation that the White House's first instinct was to manipulate the facts and smear the dead woman. And why it's all the more important that Congress meet its duty to examine ICE's abuses, its lack of training, its massive overspending. The implications of this incident go far beyond the tragedy in Minneapolis. 2 days ago, we marked the 5th anniversary of January 6th, an egregious act of political violence inspired by President Trump's unlawful attempts to overturn the 2020 election, when his followers violently attacked the U.S. Capitol, gravely injuring hundreds of law enforcement officers and threatening the lives of the Vice President, members of Congress, and the staff who work here. But when congressional Republicans let the President and his allies skate, let them evade accountability for inciting political violence against our Capitol and our Constitution, they opened the door for the killing of Renee Good yesterday. They opened the door for this administration's attempts to erase history. They opened the door for this president to pardon the hundreds of convicted criminals who attacked law enforcement officers on January 6th. They opened the door for this second Trump administration to send troops to American cities and unleash armed and masked federal officers to terrorize law-abiding communities. In 5 years, we've seen this president and his allies move from urging Americans to commit violence against our government to using government agencies to commit violence against Americans, to silence anyone who questions this White House or the legality of its dangerous agenda. It is long past time for Congress to assert itself on behalf of the American people and on behalf of our Constitution. What happened yesterday in Minneapolis was wrong, but it was the inevitable result of unleashing armed and masked federal agents on American streets to create political theater. This is wrong, and if you can't see that, then you don't belong here. I yield back.
Will the gentleman let a yield just for a
I
second?
will yield to Mr. Raskin.
I just have some UC requests, Mr. Chairman.
Gentleman can proceed.
One is from dream.org, one is from Bail Project about HR 5213. And
Without
then
objection, they'll be entered in the record.
and I have just two others. These are the minority committee staff reports that I highly recommend to everybody on the committee. One is called Where Are They Now? The Perpetrators of January 6th and the Defenders of Democracy Who Stopped Them, which follows people from January 6th. And then 1 year later, assessing the public safety implications of President Trump's mass pardon of 1,600 rioters and insurrectionists.
Without objection. I believe it's the gentlelady